So we want to welcome you very, very specially, those who are in attendance, whether you are an affiliate, whether you're a licensee, whether you're from JAMS or JCAP. In fact, it would be nice if you could just in the chat indicate where you're from so that it gives us an idea who are in attendance. We want to acknowledge one of our directors. I'm sure I saw Mrs. Reedwall, who is one of our directors. I'm not seeing her now. I'm not sure what has happened, but she was certainly on. And we want to also recognize our general manager, who is on as well. So JAMCOPY is absolutely delighted to host these series of webinars born out of, as I said, the desire to offer our creators and publishers and other stakeholders a little bit more than just matters relating to copyright and intellectual property in general. We want to ask you, as we have always indicated, to be mindful of the protocols that are involved on this platform, that we mute our mics and we write our questions in the chat in the event that you would like for some clarification or if you like further information. And at the end of the conversation, we will take them and address them accordingly. We commenced the series with of webinars or conversations, preferably. We started off by looking at the data accuracy and efficiency. And then in June, we spoke about resilience, managing stressors. And this month, we're looking at estate planning. Having a will is the better way. And our conversation today will be engaged by two most able persons, Ms. Philippa Davies and Dr. Dory Blackwood. Ms. Davis will be our interviewer, and she is our own, as I said, Philippa Davies, and she's an attorney at law and the assistant general manager and legal counsel at JAMCOPY. Our presenter, Dr. Dory Blackwood, has had over 30 years experience in the financial services industry, where she held a variety of positions, including life underwriter, training manager, director of agencies, and vice president marketing. She is a chartered life underwriter and a fellow of the Life Office Management Institute. Dr. Blackwood holds a master in business administration from Barry University, Florida, and a PhD from Omega Graduate School in Tennessee. For 7.5 years, she was the marketing lecturer at the University of Technology, where she also attained a postgraduate diploma in education. Over the years, Dr. Blackwood has conducted several courses in estate planning and corporate employees, as well as her local church. She has also been instrumental in assisting several employees, colleagues, and other individuals to reduce or eliminate the fear associated with preparing their individual last will and testament. Ladies and gentlemen, we welcome Ms. Davies and Dr. Blackwood. And so without further ado, I hand over now to Ms. Davies, who will conduct the interview.
Thank you very much, Dr. Pickney. I add my welcome to our special guest, Dr. Blackwood, and to our attendees. Thank you so much for coming to this very important discussion. And as JAMCOPY, our motto is to protect, respect, and access. Our conversations are not just about your creative works, but really looking at a live stream of the creative process. And it's very important, I'm sure, not only for you to enjoy the exploitation of your works while you're alive, but you want to make sure that you take the steps that your descendants or your heirs or whomever you would want to transfer the ownership of your rights after your passing, that they too can enjoy the benefits of your creative expression. And so the matter of estate planning is an important consideration. And perhaps you have in mind a very famous Jamaican who is now deceased, who did not make a will, and the long years in the courts and in the public domain in trying to sort out who owned what had Bob Marley made a will, a lot of money could have been saved and a lot of heartache as well. And we want to avoid that kind of scenario. So we're really grateful to have Dr. Blackwood with us today. Thank you again. So we want to talk about the business of estate planning, breaking it down, the nitty gritty, what it means, estate planning, how do we plan for the distribution of our estate, and the different instruments or methods that we can plan our estate. So Dr. Blackwood, please explain to us, what is estate planning?
Okay, thank you so very much for having me. I will be sharing on estate planning, and we will talk a bit about what is estate planning, the importance of it, and hopefully at the end of the session, persons who have not yet had a will be motivated in putting one in place. So the question was, why do we need to have a will? Is that it? Or what is estate planning?
Planning. What is
what was the question,
planning?
please?
Yes, what is estate planning?
So it's a comprehensive plan that ensures the transfer of assets that one holds to successors. The law says once you die, all your assets are going to be transferred because you can't take them with you. And so estate planning ensures that whatever you own in this life, the assets you have, can be transferred in an orderly manner after you have died. Incidentally, estate planning is just a little bit more than just the transference of assets, because it also deals with other aspects of your affairs which you may need to have handled even prior to your dying, and it deals with having in place instruments that will help you to have your estates, your loved ones taken care of after you've passed on in the manner in which you would like it to be done. Do we move on?
No, yes, please go ahead, Dr. Blackwood.
All right, so there are several tools, of which you will notice there, the will is a big one. It is perhaps the primary one and the one that involves most persons. Then there are trusts, power of attorney, advance directives, and life insurance. So we're going to touch a little bit on each of these tools. They may apply to some of us. The will certainly applies to, I think, all of us, and so does the life insurance. But there are other tools that we can use to help to get a holistic plan in place for our estate and the transference of our assets. Let's talk a little bit about, excuse me.
Right. So before we go into the tools, perhaps to say what happens if we don't pursue either of these options here.
So the big thing with estate planning is that if we don't do it and we don't have a will in place, we're said to have died intestate. The sad thing about dying intestate is that the law of the land determines how our assets are going to be, distributed. And our estate goes to the Administrator General's department and has the authority to distribute the assets that we leave behind. It's going to be administered on based on the laws of intestacy that says, in the event of our death, half of our assets will go to a spouse if there is a legal living spouse, and the other half will go to surviving children. And then if there are no spouses or children, then it goes to parents, and if not parents, then it goes to siblings, and the law just itemizes who gets the property and in what percentage. And what this means is that you don't get a say in what happens to your assets, even though you may have worked very, very hard to accumulate all of what you have. If you die intestate, then the law determines where it goes. You mentioned, Philippa, that it's a long process. It really is a long process. I must admit they're doing a little better now. But my experience with the Administrator General's department is that it takes a very, very long time, because they need to determine all the assets that the deceased had And that may be very hard to determine. Is where do you find all the properties? The person has properties overseas. Are they part owners in other properties? So a search has to be done. And then the question is, who are the persons who should inherit? Are there spouses? Are there children? Where are all the children? And so you find that it takes a long time to advertise, to tell persons that this person has passed on. And if you figure that you have an interest in the estate, then you need to apply. And so it takes a long, long time for an estate to be settled. Not only that, it's very expensive. Because when you go to the Administrator General's Department, then you incur all of these extra costs in getting things advertised, in putting things in newspaper, the time it takes. Then they sell, if it's a lot of persons who need to get money from the estate or to benefit from the estate, then sometimes they have to sell the properties, and that also takes another long time. And before you know it, the estate whittles away to almost nothing, while your heirs, your children, your spouses are there waiting and waiting. I must say that in 2016, July 13, the Administrator General's Department admitted to having $12 billion worth of assets and 3,000 cases involving children who, and those cases were not yet settled. So you have an idea of just how much money and how much in estate gets tied up at the Administrator General's office, and we want to avoid that if we can.
So having known the bad outcomes or the negative outcomes to avoid, please tell us how to avoid such a scenario.
Right, you mentioned Bob Marley having died, without a will, but there are very many other important persons who died not having a will, and billions of dollars US have been tied up. So having a will preserves your assets. It facilitates an orderly transfer to heirs. So your heirs would, be contacted, and they would know that, they have an interest in your estate. It ensures a speedy settlement. It conveys the wishes of the testator, which is the person who has the assets in the first place. It facilitates a minimization of transfer taxes, because the transfer of assets do not happen without, certain fees being paid. We have executors' fees, we have stamp duties, legal fees, estate duties. There are costs associated with all of this, plus the debt, any outstanding taxes and any debts that the person who died left. These have to be settled as well. So it helps one initially to minimize the amount of costs that are incurred in the transfer of the estate. Funds can be provided to, for all of the costs associated with the transfer of the estate. It encourages, thought. You sit and think about who you want to get what and for how long. It reduces anxiety among your loved ones, and it reduces squabbles. I am sure many of us know of properties that were left hanging, and families quarrel and argue, and nobody wants to do this, and people are unsure, and so, things just whittle away. It gives us a generational approach as well to handling our estate. Because one of the things I think we suffer from as Black people, and I'm sorry to have to put it that way because that's what I see, is that every generation seems to start over from zero. Everybody gets married, starts your house, you buy your furniture, and you start at ground zero. And there's not the care that we can take to ensure that one generation passes down land and property to the next generation. I'm sure every family will know of land and property that's there hanging around and, just cannot be transferred for one reason or another. And it becomes very, very complex down the line. By the time you get to 2-3 generations down, it becomes so complex that people just don't want to be bothered by it. And squatters come in, and that's the end of that. So what are the elements of a will? And I know we have some myths associated with making a will. Some people are terrified of making wills. I think the feeling is that once you make a will, you're going to die. Can I tell you, I've had a will for I don't know how many years, and I'm still here on the land of the living. And I've known of several persons who, in my own profession, who have made wills and they're still alive. So there's no correlation at all between making a will and dying. It's just a myth. What it does is just to ensure that your assets are well taken care of when you die. So you need to be at least 18, and it must be dated prior to your death. It must be written and signed by the testator. It can be typed, but it can also be handwritten. I think there's some will forms that you can get to buy at the pharmacy that can help with a very simple estate. And I think many of us have simple estates, so it's not a problem. And the will form guides you as to what you should write. Okay? There must be a statement that this is the last will, and that you revoke all other wills, because the only valid will is the will that is dated closest to the date of death. You should use one color ink if you're writing, because one of the things the court is concerned about is that this really represents the will of the testator. And so there shouldn't be any evidence of coercion, and we don't want anything that looks as if it's been tampered with. So we suggest use one color ink. Then you need to have two witnesses, and the two witnesses must sign on the same date. Your witnesses do not have to see what's in the will. What they're attesting to is that they recognize that you have written this will, you have signed it as your will, and they are in fact attesting and dating that they saw that this is your signature to your will. And if your will has more than 1 page, it's also good to have your witnesses put their initials on each page to say that this is what they are in fact attesting to. And it's also good to name an executor, all right? Your executor is a person who just ensures that the terms and conditions of your will are carried out. So you need to have somebody who's trustworthy, somebody who understands, business a little bit and can move around, because they have to get documentation and stuff like that.
1 second, Dr. Blackwood. Do the witnesses have to put their address and contact details, or just the name and signature?
Their name, signature, contact, yes. Contact is important because when you die, you're not sure if the person who's going to take up your will be able to find your witnesses. So it is also very, very good. Thank you so much for that. To have your witnesses put an address and a contact number, email address, whatever information they can give. And of course, you want to update this as time goes on.
Great.
Yeah.
And I'll just ask the audience, if you have questions as we go along, if you could please post them in the chat or post them to me, and then I will acknowledge them as we go along. Thanks, Dr. Blackwood.
Sure. So other considerations as you write your will, you want to put a clause that relates to your funeral and your last expenses. If you do have any special arrangements that you want to make, you want to be cremated, you want to be buried at a special spot, how the cost covering your last expenses are going, how is it going to be funded? You want to think about guardianship of minor children and dependent relatives. A lot of people probably don't think about this, but if you die and you are an only parent, you're the sole parent of minor children, you probably want to say who you would like to raise these children and leave some funding as well for, their continued existence. You want to list your properties by name and title numbers. I remember sitting with a lady and she's telling me, oh, the piece of land round that side and the part up to the tree down to the river. That won't work. You need to have your property, your land subdivided. If that is what you want to leave a piece for somebody, you need to have it subdivided, or you write in your will that you like it subdivided in this way and what is to go to whom. And you want to leave a residual clause for property that have been obtained after your will was made. It's possible that between the time you made your last will and the time you die, there, may be properties that were acquired. What happens to those? Want to do that.
Dr. Blackwood, let me ask a question from our audience. Is there a specific number of executors to be named in the will? Is there a required number, or do you suggest a certain number of executors?
I would say 2. And only because you probably want to make a provision just in case one person, predeceases you. But 1 executor is good, especially if you're updating your will on a continuous basis. 1 executor is good. to helps for checking and balancing, you know, just to make sure that the terms and conditions are followed through. So when would you need a lawyer to make a will? Well, if you have a complex estate, I would say to you, get a lawyer, somebody like Philippa, to sit with you and work it out. I'm not sure if she's an estate lawyer, but you need a lawyer who understands, you know, estate. So where there are complex family arrangements, where you have minor children and stepchildren and spouses and adopted children and children that nobody probably knows about except you, you'd probably want to ensure that your lawyer gets involved. If you want to be to charities, any special arrangements regarding trusts and stuff like that, you want to have a lawyer word them properly for you. Any complex business arrangements, like partnerships, limited liabilities, you have shares in companies, you are a partner somewhere, you are involved in running corporations and stuff like that, you probably want a lawyer to help you to determine where those shares go and how you can be bought out. And, you know, some organizations may have life insurance in place to buy out your shares. So, you know, you need to know where those go, that kind of stuff. Any kind of complex investments you may have, stocks, bonds, futures, any assets in other countries and stuff like that, you may want to get your lawyer to help you to put. And other assets such as your royalties, we spoke about the royalties you're getting from your own individual work. Probably, especially if you have several works that you're getting royalties from several places, film, music, you're also a writer, you choreograph, whatever it is that you're getting royalties from, any patents, any inventions, anything like that, you probably need to get a lawyer to sit with you and help you to determine how these are to be worded so you pass them on as seamlessly as possible to the next person. Yes.
And Dr. Blackwood, let me just pick up a question from a participant about listing your works, your books and your music rights. And a person should really consider whether they just want to lump it together and say my copyright in my music works or my books, or if they want to be specific, I'm giving music rights to someone or book rights to someone. They want to think about that level of detail. But certainly they should include my copyright, those words, my copyright in the works. And if it's possible, have a list of your works. You want as much detail as is possible.
Definitely. Definitely. You mentioned Bob Marley. Many years ago, I visited a festival they had out of town, Calabash, and there was a work that he had been involved with many years before. And it took, I'm not sure it was his niece or his daughter, who was just very insistent on ensuring that the rights to that particular work comes back to the family. And it was like years, you know, we watched it the night. So yes, it's very important for you to list all your works, all the creative works that you have any interest in whatsoever. So people know they exist and they know who are the rightful owners. Yes. So what can invalidate your will? Well, if it's not signed or dated, certainly marriage after the date of the will is important. I don't think a lot of people know that. But if you get married or remarried after the will is written, then you need to have a new will in place. I mean, it could be the same will, except that you put a new date on it, but you'll just really have to relook your will in the event of marriage. If there are no witnesses, evidence of tampering, as I mentioned before, and if there's a will with a more current date on it. All right. When to update your will? Well, we recommend at least once a year. Just look at your will, you know, once a year. Any children born after the will was prepared, you need to think about including them. Property acquired after your will was prepared, remarriage. The death of a beneficiary, you probably want to consider that as well. Death of the executor, death of any other witnesses, any liabilities on your assets, you may want to look at your will again, because liabilities then reduce the beneficiary's ownership. sale or disposal of any assets that you have. And we recommend that you use percentages rather than absolute figures, because sometimes you can disinherit somebody by using absolute figures, which is really not the intent. But if you use percentages to say, well, the value afterwards, this is how I'd like it apportioned, 1/3 to each of my 3 children, you know, that clears it up. Rather than saying to my big son, I want him to get $3 million, this one to get 2 and the other one to get 1. And before you know it, there's not even that amount of money left. So it creates, you know, problems there. So think about the safekeeping of your will as well. You'd want to put, you would want to have more than 1 copy. You'd want to have one in a safe at a bank or with a lawyer if you have one, or at 2 different locations. Fires happen, floods happen, things get, you know, damaged, things get lost. You probably want to have more than 1 will, and you want to keep it in a safe place.
Dr. Blackwood, could you just say, though, what are some examples of evidence of tampering? So if I stapled and pulled out the staple and restapled, is that,
Yes,
is that of a concern? Yeah.
That brings concern, yes, because you wonder what happened, you know, did somebody slip a page in, you know? The crossing out and it not being initialed by the testator, that is also one. Well, we certainly don't use whiteout on legal documents at all. Anything that would suggest that something was redone and we don't see evidence of the testator signing or putting an initial to say, yes, I recognize that this is a change and it was that.
Okay.
You have to be careful about stuff like that. So we move to a power of attorney. And a power of attorney is an instrument that grants somebody authority to act as an agent or an attorney, in fact, for somebody else. So it's a legal document, a power of attorney. And it says, I'm not able to act right here, right now, but I'm giving somebody that power to act on my behalf. Usually it relates to financial affairs, and it can state a period of time. It must be signed and notarized by someone with legal and mental capacity to contract. So the person who is requesting the power of attorney must be of sound mind at the time and must be of the legal age to contract. And the power of attorney lapses on the death of a grantor. So let's say a person lives overseas but have business here in Jamaica. They can give a power of attorney to somebody to act on their behalf in Jamaica to, let's say, withdraw funds, to fix houses, look after their affairs here, to transfer funds, you know, to really act on their behalf in a legal way. So your power of attorney usually state what kinds of transactions the person is authorized to carry out on your behalf, and it is usually accepted by financial institutions, all right? And it's something which is very, very important for us to consider. Any questions on power of attorney?
But the power of attorney is limited in terms of its duration and effect.
Right. That's what I was gonna
ask. Okay.
Yes.
Right.
It usually says for, you know, a period of 1 year or 2 years, whatever. And it says it also limits what transactions the person is able to carry out on your behalf, whether they have access to your bank accounts, whether they can sell a piece of property for you, you know, that sort of thing. It would specifically state what that person can do on your behalf.
Can it be unlimited in terms of time?
No, usually you put a time frame to it, and it certainly lapses when you die.
Okay.
When you die, it just comes to an end.
So if you want to think about these two instruments, power of attorney while you're alive,
yes,
and then the will after you've passed.
Right. Because once you die, then it's your executor now takes over acting on your behalf. So just to prevent any confusion there, that's what happened. So trusts, what are trusts? We tend not to use trusts very much, but of course we hear about it. A trust is a legal entity created by one party called a truster, through which a second party, the trustee, holds the right to manage the truster's assets or property for the benefit of another person. God, this is just so much, so wordy. It's a fiduciary arrangement, one that, is based on trust and goodwill and, and just an understanding of arm's length agreements and stuff like that. So let's say I have a minor child and I want to make arrangements for that child to be supported after my death. And I want to ensure that there is enough funds to support that child, and that the funds or the assets that I leave will be used specifically to support that child. Then I can set up a trust. I think some of us would have remembered what happened to Whitney Houston. And when she died, she had set up a trust for her daughter, and that certain sums of money would be paid out periodically. And then if the daughter died by a certain time, then all the monies and the other assets in the trust would revert to her mother. And that trust was what saved her estate from the daughter's husband, who was then somewhat, I don't know if he was implicated, but certainly he was a person of interest in relation to the daughter's death. So it's when we hear things like that and we realize how important a trust is. If you have relatives who are disabled, if you have relatives who are dependent on you, then it may be important for you to set up a trust so that there are funds available to take care of those relatives for as long as they need the funds. It's just one another way you put in place something that helps your estate to get to the persons who want it to get to, and for as long as you need it to be there. Please tell me how I'm doing in terms of time. Now, there are four main types of trusts. There's a living trust that can be created while the truster is alive. There's a testamentary trust that can come into effect after I die. So I can put in place a trust that says, on my death, if so-and-so is of such or such a age, then that is what I want to happen. I want this house to be rented, and the income from the house, which should be whatever, should be paid to my daughter until the age of whatever. So, you can have testamentary trusts. Then there are revocable trusts that can be modified or terminated, and you have irrevocable trusts that once you put them in place, they cannot be modified or, terminated. So trusts are, important. Now, there are companies that can set up trusts for you, but you can have a relative who you have faith and confidence in, or you can have your executor, if that is somebody who is, a reliable person and somebody you trust, to also be a trust, set up this trust for you, and to ensure that persons who should benefit from the trust do so over time.
So, Dr. Blackwood, can you have a revocable testamentary trust, or is it only a revocable living trust?
No, you can have, well, if it is only going to be modified by the trustor, then I would think that you are the one would have to do that. But you see, that's why we need legal advice sometimes, because given the nature of what we're entering into, we would probably want to say the person to whom the trust is set up, that they perhaps could have a say in what happens at a point in time. So let's say you're setting up a trust for a child. You'd probably want to say when that child gets to whatever age, then the funds or the assets, may be reverted to the individual, and they then can do whatsoever they wish to do with it. The wording is just very, very important as you set up these instruments.
Someone has a question in the chat. Should we then be encouraged to sell properties and invest the cash?
The minute you sell your property and you have the cash, then you realize that you're not going to be able to get the higher value that you probably can. Let's say real estate, for example. Real estate tends to move very quickly in value. It's probably one of the more stable of all the investments that you have, well, certainly in Jamaica at this time. If you sell your property and take the cash, then you're forfeiting that, right, that ability to earn on it. But let's say you're advanced in age and you certainly need the cash and you really just can't be bothered with maintaining a property, then it's your choice. You can determine what you do with your properties. But yes, if you sell the property ahead of time, then you avoid a lot of, or you can avoid a lot of the transfer costs associated. It's one of the tax minimization strategies that you have in terms of your estate. But just remember that once you have the cash in hand, it is not as easy for you to get the value, to get the investment increase that you would get on cash as you put on property. And besides, Jamaicans tend to have an affinity. We tend to like the fact that we can own land and we can own property and we pass things on to our children or grandchildren, somewhere that gives them that level of security. But it's always up to the individual, to sell or not sell. Now, an advance directive is a document that allows one to make decisions about medical care he or she would want to receive in the event you become incapable of making the decision. I think in the States it's legal and can be enforced. I'm not so sure it can be enforced in Jamaica. Philippa probably can help me with that. But it certainly helps the persons who are alive and who have care for you to make decisions on your behalf according to your will and wishes. Philippa, can we enforce it?
I think it would have the same kind of effect as almost like a power of attorney in terms of setting out certain instructions on a particular aspect of your life or your life business. Yes, it could have effect.
Yes, can I share with you an experience that I have? It's not a personal one in the sense that it didn't happen to me, but it happened to a friend of mine whose mother at the time was 95, very ill, and they had put her on life support because she had difficulty breathing. And she was also being fed by a tube, and she had developed an infection in her throat. So the doctor said to her, this happened in Canada, that the doctor said to her, this is the daughter, if we're going to pull out the tube to deal with the infection, then we might as well take your mother off life support and let's hope she can breathe. Now, my friend kept calling me, like every night, what do I do? And I'm saying to her, well, what would your mom want? But her mom's mental capacity had deteriorated to the point where she wasn't sure when she spoke to her mother from one day to the next, whether her mother was lucid enough to say what it is she really wanted. So the decision came down to that one daughter. And can I tell you that when she made the decision, I said to her, well, what the doctors say? When she made the decision to pull the plug and her mother died, it took her 2 years in counseling to come to terms with the fact that she really didn't kill her mother. So it is very important for us to write these things down, to say to other people, what do you want to happen if you're in a position where you can't speak for yourself, you can't indicate in any way, shape, or form whether an operation needs to happen, whether you need to be resuscitated if your heart stops, whether you're on life support and it should be removed. Remember this lady in 1995, Mrs. Shriver or something like that in the States? She had been on life support for 15 years. You can look up the case. And after 15 years, her husband wanted to pull the plug. But the lady's family says no, because we are the ones taking care of her. And so it became a battle till it went to the court. And then the court threw it out and said, no, this is a personal, private family decision. You all have to make that decision. The court does not make decisions concerning stuff like this. And it was like a legal battle for such a long time. And eventually the husband, because he was next of kin, decided he was going to pull the plug. And, people were just very, very unhappy. So it's very, very important that we make these decisions for ourselves while we're alive, while we're in our right minds, and we can make these decisions so other people know this is what we want, and they can easily make decisions for, well, certainly say to our doctors and, you know, caregivers, this is what she would have wanted. So that is what our advance directive does for us.
And again, also to overcome that fear and the myth that if I talk about anything to do with death and my passing, that it is going to, you know, cause it in a premature way. But we have to have these discussions, even talking about what kind of funeral you would like and hymns to be played if you're a churchgoer, but not to fear, but actually to think about, I want to avoid the pain, the extra pain and stress of having to handle these administrative matters because they weren't discussed while the person was alive.
And the uncertainty, you know, I'm not sure this is what she wanted, so I do what is expedient, or I do what is recommended by the doctor. And then the last one is life insurance. Now, I know we don't like to talk about life insurance. It's just one of these goods that people don't go for generally, but it's just so important when we think about our estate planning. So the good thing about life insurance is that the face amount, the total face amount, is payable at death. And what it does is to create an immediate liquid estate. If you don't name estate as beneficiary, if you name somebody as beneficiary, then the money is paid directly to the beneficiary. And then this money has become available now to pay last expenses, to clear up the estate, to deal with the court, the stamp duties, the legal fees, whatever needs to be done. So it really helps to speed up the settlement of the estate. Because it is cash, it's not subject to tax. And it can be used to replace income, especially when there are small children, until the estate settles and there are funds available to provide an ongoing income to the family. So it's very, very critical for you to have life insurance. If you sit with your life insurance agent, they'll help you to work out just how much you can afford, how much is good for your particular needs at this particular point in time. So it's very critical for us to all have some amount of life insurance in place. And the younger you are, you know, the cheaper life insurance is. And so we need to all have some amount of life insurance in place, if for nothing else, to help our estate settle.
Dr. Blackwood, how about putting names also on? Okay, I think you're going to come to that.
Right. So we're just talking about some of the tax minimization strategies. Now, we can lose quite a bit of our estate in terms of the costs it takes to transfer the estate. You know, as I mentioned before, you're going to have executor's fee, which is usually 6%. But if you name members of your family or you name a beneficiary as an executor, then chances are that person will not necessarily want to take the full 6%. So that can also help to minimize the cost of the estate. But there are stamp duties and there are legal fees. Your legal fees will probably range somewhere between 7 and 10%. Then your estate duties, after we take off the first 100,000 of the cost of the estate itself, of the real assets that you have, then the balance is subject to 1.5% taxes. Now, how people tend to lose their estate is that if the estate is not settled within like a year, then the government starts charging 6% on that sum that is due and payable. So the longer it takes the estate to be settled, is the higher the fees that you have to pay to the government as transfer tax. If it remains unpaid for a long time, then you find that the fees and the associated costs and all of that mount up so much that after a while, you'll probably have to pay out, I don't know, half, 3/4 of the value of the property for the taxes, and people they feel they're not worth, it's not worth it, so they don't bother. But what happens is that you can't use the property for collateral in any way, shape, or form, and it just stays there. And after a while, when you die and the other generation of persons come, it becomes a lot more complex as to who think they have rights to the estate, and then it has to be transferred 2-3 different times, and the cost just becomes horrendous. So it's very important that we leave enough money to just deal with the transfer of the estate as quickly as we can. Another way to minimize the taxes or the costs on the estate is to have joint ownership. So if half of the property is owned by somebody else, then when you die, then it's only the half that you own that the transfer tax will be, charged on at that point in time. Now, there's a question about joint tenancy and tenancy in common. Joint tenancy means that the survivor gets it all. So if you own it in joint tenancy with, let's say, a spouse, when you die, then the half that you own goes to the spouse, the living spouse. Yeah? If it is tenancy in common, then each of you own a half of the property. And so the survivor has, you, the person who are deceased, can in fact bring your piece or your half to whomever you feel. All right? And then you have to think about the ramifications of all of that and what it means. Then there's inter vivos transfers, which you can do while you're alive. We kind of hinted at that earlier on, where we say you can transfer the property while you're alive, and then the costs are a little less at that point in time. Or you can sell the property. If you sell the property and bring it down to cash, then of course you really don't have that transfer to pay. So you have leeways, you have ways of dealing with it that helps you to minimize and to ensure that there is enough liquid cash to pay so that your estate can be settled expeditiously, quickly, so you don't get the added costs associated with time.
And also joint account, joint two names on the bank account, or if there are other financial investments or policies you may have, put in two names as well or more.
Stocks that you own. If you have a portfolio of investment instruments, you probably want to have somebody else's name as well on those instruments. Because if you die, then the question is, what do we do with it? And the banks are going to insist that somebody needs to have access to some legal means, or we can't pay it over.
You talked about if it's not settled within a year. What does settled mean?
Well, we'd want to ensure that the new owners, their names are on the property, and that things are transferred to whomever you have declared that they should be transferred to, that any indebtedness on your estate has been settled, because that has to be done. I mean, when you die, your debts have to be paid, your debtors come first. Worse, if you owe money to government, they're the first ones that come in to ensure that there's, So the settlement of your estate means that all the legal ramifications of your estate are in fact dealt with. All the costs have been paid, and the title to all the properties are transferred as outlined or as dictated or as bargained for, because the fact that you have a will does not mean that people can't contest it. Yeah? But we hope that you would be, I always tell people to think about carefully your will and how you want it to go, so that you minimize the possibility of persons wanting to contest your will. You want it to go as smoothly as possible. So think about it carefully, There was somebody in the States, I think, these things don't happen in Jamaica, but some of the States, somebody left 12 million pounds or dollars somewhere to some dogs. And of course, the daughter took the whole thing to court and said, well, I mean, why does a dog need $12 million? I mean, yeah. So they worked out what's the lifespan of the dog and who's going to take care of the dog and how much the dog needs each year, pay that money to the dog, and then the rest, is paid to her as the living heir. We just have to be careful. That's all I'm saying. Let's just be careful and be very thoughtful when we are leaving properties.
So Dr. Blackwood, if everybody follows what you have said today and puts everything in place, they have their will or their trust or their advance directive, whatever they've thought through carefully, even after they've passed, there's still another step. You want to speak a little bit about probating the will and what that is about?
The probating of the will is just ensuring that it goes through the courts and that the court declares that this is de facto the last will and testament of the person who has been deceased. So it is submitted to the court as the document, and it goes through the scrutiny of the court, and the court says, yes, it is the last will and testament. So some of the things we spoke about earlier that could invalidate a will is what they're going to be looking for and looking at. Is this the real signature of the person who has passed? Was the person in a right state of mind when this will was made? So the beneficiaries will also be called into question. Did you really see that this was in fact the last will and testament of this person, or not? So that's what the probate is about. And then the probate now gives the executor the right to then move along with settling the estate according to the will of the testator.
Right. Do you have to probate every will, or is it really where there's large assets involved?
Every will does not have to be probated. I mean, a simple will does not necessarily have to go to probate. There are some situations in which, let's say, a person leaves property for their children. Let's say they had 4 or 5 children, and they say property is to be sold, and each of the children gets equal shares. Then the children can get together and talk about it, and they sell the property, get their portion. And it really only gets to probate if there are complexities, if it is difficult sometimes to find the persons who are beneficiaries, if you have properties scattered all over the place, United States of America, in England, Canada, very, very complex, then we'd probably want to ensure that goes to court and that all of that is settled.
And for the benefit of our affiliates, let me say that under our rules at JAMCOPY, the copyright, it continues under the laws of copyright in Jamaica. The benefits under copyright continue for 95 years after that creator has passed. So you must include it in your will that you are bequeathing your copyright in your works to whomever you so decide. And under JAMCOPY's rules, that beneficiary can come to JAMCOPY and join in your name and benefit from the royalties that we would distribute to our rights holders. But we would need to have proof that you are a beneficiary of that asset. So either you bring the probated will so that there's no question that this will is accepted and determined to be valid by the court, because we wouldn't be able to look at the will and say, we agree and we confirm what has been written under the will. It has to be probated by the court, or the letters of administration if there was no will, to say from the government again that you are the beneficiary of the estate of this person who has passed. So please make sure you put it in your will, but if not, letters of administration or the probated will, and then you would come to JAMCOPY, or rather your beneficiaries would come to JAMCOPY, and then they would complete the affiliation agreement, and then they would receive the royalties that you would have been entitled to as a rights holder. So very important to prepare your will. Yes, Dr. Blackwood, is there anything else you'd like to share?
This is it, unless anybody has any additional questions.
We do have a couple of questions that I was saving. So a question that was asked was the power of attorney. Should that person be different from the executor, or should the executor be a different person from the power of attorney? Or could you have the same person serving in both capacities? So the person that you name in your executor, could it be the one you may have given power of attorney during life, or?
It can be. There's no law that says you have to name a different person. It's somebody who you trust. It's somebody who you know will be fair and reasonable in just carrying out your wishes. It doesn't have to be two different people. It can be the same person. Yes.
Okay.
However, what you don't want is for your beneficiary to be your witness. I think that is important for us to state, that the person who is witnessing your will should not be a beneficiary under the will. I think we never really said that, and that is important for us to say. But other than that, yes, your executor could also be the person who has the power of attorney.
Okay, we have another question asking whether the advance directive is also called a healthcare proxy. Have you heard that term, and whether it's
I've
a
never heard
similar?
the term. I really have never heard the term.
Okay.
But I don't know.
If it is
somebody
about,
who makes, yes, sorry.
right, if the intention of that document is to give clear instructions to other persons, what should happen to you if you fall ill or you're incapacitated or you're not able to speak for yourself, then if that's the intention, then it would have the same objective as an advance directive.
Yes.
Okay, another
and
question.
Speak to the people who are around us about our wishes. We need to speaking about it. I know it's a little difficult conversation to have, but we need to let them know what our wishes are.
Okay, we have another question. If your name is on a land title, can the spouse of the deceased claim the property? Now, I don't know who the you is. Maybe if the participant would like to clarify whose name is on the land title. Is it the spouse? Is it another family member? If maybe you could clarify that for us to answer.
And also what property? Is it land? Is it a house?
Yes,
Is it
yes.
estate?
I said, if your name is on a land title, can the spouse of the
land
deceased
title.
claim the property?
And is it that it's owned jointly, or is just one person's name that's on it?
Okay. If the child's name is on the land title, can the spouse of the deceased claim the property?
Oh.
If the child's name is on the land.
If a child's name is on a property, we're assuming that this child is not a minor. If the child is an adult, then the child is the owner of the property.
Okay, so an adult child.
Yes.
And then the spouse of the deceased, can the spouse claim the property? But it will depend on whether it is joint tenancy or tenants in common.
Is it that is jointly? I'm not sure. If one person's name is on the title, then that's a person who owns property outright. If it's owned jointly, then usually it's a 50-50 split, and it's going to be either joint tenancy or tenants in common. If it is joint tenancy, then it means that on the death of one, the other person gets the property. And there can be no argument as to the ownership rights under those agreements. Yeah. The thing with property is that it's very clear. Whoever has a name on a property is the owner of the property. So the argument there is, I know there was a case that happened but it happened in England, it wasn't in Jamaica, where there was an estranged spouse and that somebody was living with somebody else for many years, and that went to court. But otherwise, once a person's name is on the property, it belongs to the person on the property.
Mm-hmm. Well, the participant said thank you, so I guess the question has been answered.
I hope I haven't confused them more. But you see, the circumstances is what would determine why the spouse would be claiming the property in the first place. What reason would you have to give to the court to say, I have an interest in this? There's got to be a reason.
I have one more before I hand back over to our moderator. The participants said that they asked a stockbroker a few years ago to add another name to their equity account, and they were told that it cannot be done after the account has been set up. It should have been done at the start. Can you shed any light on this?
I can't tell you the rules of the particular. I can't tell you the rules of the particular. Yeah. But you know, he's probably right. Once the stocks are purchased in the name of the person, then to add another name creates some issue. It would create some issue. So the important thing is, but I've seen where people have had like bonds, and if you say that it should be owned jointly, that it can be joint. That what you do is you relinquish the original agreement and you sign up forms now that says these are joint owners. I can't say what it is that the investment house, what their rules are, but it's not, I don't think it's impossible. I really don't see it as being impossible.
Okay. Well, Dr. Blackwood, thank you so much for demystifying many of the issues that we've had in mind or heard about estate planning. It has absolutely been practical and useful what you shared with us today. And I think we should all go home now and write our will and prepare ourselves.
Please, believe you me, the peace of mind you have, just having that in place is invaluable.
Yes. Well, thank you so much. And I hand over to Dr. Pinckney.
All right. Thank you so much, Dr. Blackwood and Ms. Davies. Thank you so much for the session. We are seeing the comments in the chat expressing appreciation and very informative and so on. I wonder if anybody has any particular takeaway from this presentation. If you would just like to put it in the chat, what is your takeaway? Yes, it is informative. Yes, it was very well presented. Yes, it was, the interaction was good. But what is your takeaway? There's several, and certainly we hope that a main one is that if you don't have a will, you'll go write one. Yeah, and we really want to express thanks and deep appreciation to Dr. Blackwood for taking the time to share her wealth of knowledge to us. We also want to, okay, so I'm seeing the takeaways. It's important to write a will, yes. We want to also express appreciation to Ms. Davies for so ably guiding us along and sharing our questions and complimenting Dr. Blackwood in the presentation. So we want to thank all the attendees. We really do appreciate you coming on and sharing with us during this period of the day. And we hope that the session was very informative. We hope that you are going away with strong takeaways and with a new will, no pun intended, to make a will, and that you, pardon, you will be able to go forth and do accordingly. We want to ask, I know our general manager is on. I don't know whether she has any final words before we close, but we want to again say thanks to Dr. Blackwood, thanks Ms. Davies, and thanks to everybody who has have joined and really made this evening a success, I would think, this afternoon a success. So Ms. Newman, any last comments from you, or should we just go right ahead and close?
I would just say thanks to everyone, and a special thanks to Dr. Blackwood for joining and sharing with us this information, very important, particularly for our creatives. As you would have been reminded, copyrighting your work lasts your lifetime plus 95 years. So that is several generations there to benefit from your creativity. So it's very important that you ensure that these persons are able to benefit with as little challenges as possible. So thank you again, and I hope you'll all take stock and use the information that you have gathered. And thanks to the staff for the hosting. Thank you very much.
Thank you, Ms. Newman. We noticed that one of our directors, Patricia Reedwall, has rejoined us. I think maybe she got disconnected, but it's good to have her on and to acknowledge her as one of JAMCOPY's directors. So please look out for more conversations beyond the book. We are open also to your suggestions if you have any that you want to make. And as long as we can, because of course we have to find able persons to facilitate the sessions, but anything that you think that would be good on this platform through or through JAMCOPY's management, that we will try our very best to facilitate as best as possible.
And
so
also,
go ahead.
Madam Moderator, just also to say that we are still trying to find the optimum time slot for this session.
Right.
Please share your comments as to the convenience of the time, make suggestions about time slots and so on, so that we're still searching for that optimum time slot.
Great. And someone is asking whether the recording will be available. We usually post these conversations on our website, JAMCOPY's website, which is www.jamcopy.com. So just give us a few days and we will have it up on our website. Thanks to all the affiliates who joined. Thanks to all the licensees and other stakeholders, friends and family all. Thank you so much. And we really, really appreciate your presence. And thanks again to Dr. Blackwood and Ms. Davies for their time and for the presentation. We look forward to the next conversation. But until then, we say, have a good rest of the evening. Bye-bye.